Again, today we're very fortunate to have with us two attorneys who were involved in arguing this case before the Michigan Supreme Court. Timothy P. Flynn, partner, Carlstrom Cooney LLP, Clarkston, appellate counsel for the defendant, and Timothy K. Morris, whom you just saw on camera there, Chief of Appeals, St. Clair County Prosecutor's Office, appellate counsel for the prosecution. Gentlemen, thank you so much for being with us. This is going to add a great deal to our discussion, and I'll let our student hosts go ahead with their battery of questions.
This is for both attorneys. How did you prepare for this case?
You were the appellant, sir.
Well, ordinarily I'm not the appellant. Ordinarily I wait until the defendant's attorney on appeal tells me what the issues are going to be. In this case, that's precisely what happened in the Court of Appeals. Is we responded to the brief and went and argued and lost. Then we decided we would apply for leave to the Supreme Court. At that point, my job is to figure out how to get 4 justices to say we want to hear this case. We want to do something with what happened here, which is really different than responding to somebody else's argument. So I basically have to frame what did I think was wrong in terms that will attract the attention of Justice Young and 3 of his colleagues at least. And to do that, I went back over the trial briefly, and then I started to investigate the law. Now, you've only got 21 days to make your application for leave to appeal to get it started. So essentially, the application for leave to appeal is kind of an outline of what you think you're going to be able to prove to the court when you get a chance to lay it all out before them in a full brief with oral argument. And I started to look at our felony murder statute, which is based on an 1796 Pennsylvania statute. Ironically, Pennsylvania amended that many years ago, so our statute no longer bears any resemblance to the current Pennsylvania statute. But that statute was the basis for the most of the felony murder statutes in the United States up through the early part of the 20th century. So there's a lot of case law from other jurisdictions, there's a lot of case law from Michigan on what felony murder is. And basically trying to figure out what is going to attract the attention of the justices. And that's how I started to prepare for it.
From my perspective, Darrell, Mr. Morris specializes in appeals. He only does criminal cases, so when that 55-page brief was delivered to my office after a phone call from Mr. Daly, who you saw arguing the case, it sort of hits my office like a bomb. We've got 56 days to write our response to the brief. It's at the Michigan Supreme Court level, so it's not a casual endeavor. It's something that I think Mr. Morris had cited some 450 some odd cases that we have to look at. My staff immediately gets copies of the brief and then sets about making copies of these cases and putting them in binders, because we have to look at those. In addition, I need then, because I was not the attorney that tried the case, I had to read the trial. And unlike Judge Adair, who described, and he has these memories, very significant memories of the witnesses and the actual live people testifying in his courtroom, by the time it hits my office, like I said, like a bomb, it is in 3 or 4 red rope trials. It's down to paper now. And we need to get into that law and address the arguments that my very able opponent has raised. But he's right. Normally, he's responding to a defendant's chance at reversing a conviction. We had already got the intermediate appellate court to reverse the conviction, and it was going back down for another chance at freedom, or at least a different sentence for my client. So that's the beginning preparations. That's how we set about responding to the brief.
What's the most difficult part of those preparations?
In this particular case, there's 3 challenges. The first is that you've got a client that's hired you. He's killed 2 people, okay? He's the bad guy, and it's your job to fight for the bad guy. As far as the the community in St. Clair. This is a jury who, in my mind, is an appellate counsel. The jury has spoken, and that's the community. They dislike him. As far as the family members of the victims, those victims are dead. They hate my client. So you need to be, as an attorney, you're professional. You set those feelings aside. You set those community feelings aside. Also, another challenge, by the way, was that in this case, unusually, we had the Court of Appeals saying he's going to get another chance. So you got your client's family very hopeful in this case. They want a good result. So they've paid you to begin this process. So you got all these emotions and bad feeling toward your client. But you are the professional soldier. You set the feelings aside, you focus, and you get to work on responding to Mr. Morris's brief. That's the second challenge. As I say, very worthy opponent. You need now to match his work product with your own, a completely different viewpoint. He's come up with some fantastic arguments that had common law drawn from all of the 50 states just about. I think there were hardly a state, I remember citing cases from Hawaii and Alaska in this brief. And you have to look at all those, so that's a challenge. And again, within 56 days, this has to be done. So all the other clients you have, because I'm in private practice, I don't get a government paycheck, these other clients get set aside for this 2 months. And you have to focus on this brief. So that was the second challenge. And then the third challenge, I think, is due to the appellate process. There are some months that go by after you write this brief, and it's you're sleeping at night thinking about these cases, and it's the most important thing in your professional life. But then 6, 7 months go by. Other cases come in, and you get the notice from the court, from the Supreme Court, that it's your time now to come in and argue it. So you have to reacquaint yourself to the case, what you wrote, and appear in front of some very, what I would describe as intellectual heavyweights, 7 attorneys that have risen to the top of the judicial system. They all have their own jurisprudential philosophies that you try to familiarize yourself with, but you're the soldier standing tall in front of them, trying to anticipate their questions. And let me tell you, I mostly appear in front of panels of the Court of Appeals, but when those judges or justices ask those questions, they're very direct, and you better have a good answer. That also is very challenging.